Lords, can I turn next to the control issue, ground
Yes.
5? For your Lordship's note, we deal with this from paragraph 105 and following of our skeleton. That's at page 75. And as your Lordships will recall, this issue arises because of the two claimants in the action. Only one has thus far been designated by His Majesty's Treasury. That is Bank Equity, the second claimant. NBT, the first claimant, has not yet been designated in its own right. And so the question is, what about NBT? As your Lordships will be aware, our case is that NBT is owned or controlled by at least one designated person, namely President Putin or Ms. Nabiullina, and as such, also forced to be treated as if designated. As your Lordships will have picked up, there was before the learned judge extensive factual and expert evidence concerning the question of control. But all of it, or the relevance of all of it, fell away shortly before the hearing before the learned judge because the claimants conceded just before the hearing that subject only to one point of law, NBT is, and indeed is owned or controlled by President Putin or by Ms. Nabiullina for the purposes of Regulation 7. And for your Lordship's reference, that's in their skeleton, the Learned Friend skeleton below, paragraph 109.3.2, supplementary bundle, tab 16, page 351. That concession was described by the learned judge at paragraph 202 of the judgment as sensible and realistic. And we respectfully submit that that should have been the end of the issue, but the learned judge held, tentatively, as the learned judge put it, that's at paragraph 233, that there is in the regulations, and Regulation 7 is the regulation with which we're concerned, what she described as an implied carve-out, which meant that any control exercised by a designated person, if that control was exercised by virtue of a political office held, was to be disregarded. And the issue that arises on this appeal is whether the learned judge was right about that, because if she was not, it is common ground that the test of control is satisfied and that NBT2 should be treated as a designated person. Your Lordships would have picked up that as we respectfully submit, the learned judge's conclusion about the proper interpretation of Regulation 7 is wrong, and we respectfully submit clearly so. Can I just give your Lordships a roadmap of my submissions on this issue? I propose first to make some submissions about the language of Regulation 7, then to deal with whether there is a carve-out, as found by the judge, for the control exercised by virtue of political officer alone, as the judge held. And I'll pick up in that context what I would describe as my learned friend's still more extreme case for a more extreme carve-out, which is advanced by way of respondent's notice, which would include a carve-out not only for political office, but for control exercised by corporate office as well, which is my learned friend's case. So beginning with the language of Regulation 7, your Lordships will find Regulation 7, Volume 4, tab 16, page 912. Just looking at it, meaning of owned or controlled directly or indirectly. A person who is not an individual C is owned or controlled directly or indirectly by another person P if either of the following two conditions is met, or both are met. Then sub 2, the first condition is that P holds directly or indirectly more than 50% of the shares in C, and B holds directly or indirectly more than 50% of the voting rights in C, or C holds the rights directly or indirectly to appoint or remove a majority of the board of the directors of C. And then 3, Schedule 1 contains provisions applying for the purposes of interpreting paragraph 2 and then subparagraph 4. The second condition is that it is reasonable, having regard to all the circumstances, to expect that P would, if P chose to, be able in most cases or in significant respects, by whatever means, and whether directly or indirectly, to achieve the result that the affairs of C are conducted in accordance with P's wishes. Now, can I make 5 points arising out of Regulation 7? First, Regulation 7 has been in existence since 10th of April 2019, which is the date the 2019 regulations were enacted. And, as is perhaps obvious, Regulation 7 must have meant something on that day. And the issue before your lordships is what regulation properly considered meant on the day it was enacted, because, of course, the meaning of a statutory provision cannot change based on subsequent events. So, my lords, if the learned judges, or indeed my learned friends, suggested implied carve-out exists, it must be shown to exist as a matter of construction on the day the regulations were enacted, without reference to subsequent events. Secondly, following on from the first point, the meaning of Regulation 7 cannot change depending on individual designation decisions made by the government. And we say, with respect, that one of the principal errors in this part of the learned judge's analysis is that she sought to draw inferences about what Regulation 7 means from the government's decisions to designate or not designate certain individuals. And I'll obviously come back to that. Thirdly, and still on the language of Regulation 7, if your lordships look at the opening words of Regulation 7.1, your lordships see that it says that there is control if either or both of the conditions they're satisfied on it. It follows that the first condition, that is to say Regulation 7.2, and the second condition, Regulation 7.4, are alternatives, and that the control test with which the paragraph is concerned is satisfied if either of those conditions are satisfied. It follows further that whilst there may be circumstances in which both apply, there will also be circumstances in which the legislature envisaged that one might apply but not the other. None of these points are profound so far. I'm not saying they will get to anything. Fourth, just looking at the first condition in Regulation 7.2, your lordships may have picked up that my learned friends appear to rely on the use of the word hold or in that paragraph, and they contend by reference to that Regulation 7.2 is concerned with control through personal ownership and personal rights. That, for your lordships' note, is paragraph 108.1 and 108.4 on the learned friends skeleton. And the learned judge appears to have accepted something similar to this, because at paragraph 237 of her judgment, she referred to the terminology of holding in concluding, as she did, that Regulation 7.2 is essentially about ownership, direct or through a chain of company or nominees. And my lords, we respectfully submit that whilst it is certainly the case that Regulation 7.2 does indeed include, within its scope, control through ownership, direct or indirect, it is not correct to say, if this is what is being said, that this is as far as it goes. The problem we submit with the analysis advanced by my learned friends, that appears to have been possibly accepted by the learned judge, is that it depends upon an understanding of the word hold that doesn't have a proper basis in regard to the way in which the word is expressly defined for this purpose by the regulations themselves. And just on this, if your lordships can glance back at Regulation 7.3, your lordship sees that it directs one to Schedule 1 to the regulations for the purposes of interpreting paragraph 2. Your lordships will find Schedule 1 at page 1053. 1053. I invite your lordships to go to that. Just looking at the first paragraph of that, 1053, Schedule 1. The rules set out in the following paragraphs of the schedule apply for the purposes of interpreting Regulation 7.2 and 16.7. Your lordships don't need to bother with 16.7, it's just 7.2 we're concerned about. And I ask your lordships next to look at paragraph 9, in page 1055, which defines what is meant by holding a share indirectly. And if I can ask your lordships just to glance at that. If I can draw your lordship's attention specifically to subparagraph 2 and 3D. So subparagraph 2 is dealing with a situation where a person holds the right indirectly, where that person has a majority stake in another person and that other person holds the right as part of a chain of persons. And then subparagraph 3 says this: for these purposes, a person A has a majority stake in another person B, and then if your lordships glance at D, if A has the right to exercise or actually exercises dominant influence or control over B. And so we respectfully submit that 9.3d is apt to capture the case of a designated person who, for whatever reason, is actually able to exercise control over another, presumably a company. This seems to apply whether or not that person has ownership or indeed any other right of control. It applies where that person either has the right to exercise, well that may be by virtue of the shares or otherwise, or actually exercises dominant influence or control over B. It would therefore appear to apply not only to persons who are shareholders in the owners of the company, but also to others who are not. And there is, we would submit, certainly nothing at all in the language here to suggest that this provision is relevant only where that control arises as a result of personal ownership and nothing else. It doesn't say that, and there's nothing there to suggest that. Can I ask your lordships next to go to paragraph 11 of Schedule 1? Page 1056, where a person controls a right, the right is to be treated as held by that person and not by the person who in fact holds the right, unless that person also controls it. A person controls a right if by virtue of any arrangement between the person and others, the right is exercisable only only by that person in accordance with that person's direction or with that person's consent or concurrence. And then under paragraph 12, arrangement includes any scheme, agreement or understanding, whether or not it is legally enforceable, and any convention, custom or practice of any kind. And again, my lords, we say that that again is apt to catch the case of a person, say a designated person, who without being an owner has sufficient influence or power, possibly by virtue of a contract, commercial arrangement, to control the exercise of a right held by another. Now, my learned friends suggest, this is at paragraph 108.4.3 of their skeleton, page 130, that this is analogous to a situation where a company is owned through a nominee. But with respect to them, my lords, it seems unlikely that this is what this is about. First, because this is not what paragraph 11 says, just looking at the language used. And secondly, because as my learned friends themselves recognize, paragraph 108.4.3 of their skeleton, nominee ownership is in any event separately addressed at paragraph 10. The lordships may want to glance at that. The share held by a person as nominee for another is to be treated as held by the other, and not by the nominee. So paragraph 11 must be doing something else. That's to say, capturing a position where control exists otherwise than because of a nominee arrangement. So we submit that the learned judge was wrong as are my learned friends, to interpret Regulation 7.2 as confined to ownership, or as my learned friends would have it, what they describe as personal ownership. And I'll come to what that means now. So that is our fourth point about the language of Regulation 7. Now, thus far, all the points I've been making have been concerned with Regulation 7.2. My fifth point concerns Regulation 7.4. And again, if your Lordships just go back to that and just glance at it, it's at page 912. Second condition, so this is one of the two conditions which need to be satisfied. The second condition is that it is reasonable having regard to all the circumstances to expect that P would, if P chose, be able, in most cases or in significant respects, by whatever means, and whether directly or indirectly, to achieve the result that the affairs of C are conducted in accordance with P's wishes. Now, as your Lordships will know, we submit that the words all the circumstances and by whatever means are significant because they demonstrate, we submit, what is perhaps an obvious point, namely that Regulation 7.4 does not have any limit on the means or mechanisms by which the designated person is able to achieve the result of control, namely that the affairs of C are conducted in accordance with their wishes, by whatever means. What matters, my lords, is the ability to achieve that result, rather than the means by which the designated person has that ability. And in considering that issue, one is to have regard to all the circumstances, again, without limit. To put that in more informal language, my lords, Regulation 7.4 applies if the designated person calls the shots, or can call the shots. But how the designated person calls the shots is irrelevant. Now, as your Lordships know, despite the width of this language, the learned judge held, this is at paragraph 237 of the judgment, that Regulation 7.4 is, in her words, essentially backstopping any form of ownership that falls slightly outside 7.2. So that's at page 192. I'll show that to your Lordships. So 237. It's paragraph 237. Essentially then is forced to the submission that 7.4 is essentially backstopping any form of ownership and control which falls slightly outside of 7.2. In other words, so the submission went, and it's a submission which at least tentatively seems to have found favour with the learned judge. Regulation 7.4 is to be treated as simply ancillary to Regulation 7.2 and therefore also about ownership or about something close to ownership. Falls slightly outside 7.2. The learned judge having concluded that that was about ownership. Now, the learned friends advance a similar argument in paragraph 110 of their skeleton. That's at page 130 of the bundle, where they too contend that Regulation 7.4 is intended only, in their language, to plug the gap, where a designated person, again, this is their language, has effective personal control over a company, but the situation doesn't fall within Regulation 7.2. So plugging the gap where a person has effective personal control is the language they use. And my lords, we respectfully say that this is wrong. Our submission is that Regulation 7.4 is not meant only to backstop a form of ownership that falls outside Regulation 7.2. And I'll address your Lordships on that in a moment. But before I do that, perhaps I can just make this point. Even if it were the case, and we say it isn't, But even if it were correct to say, as the learned judge did, that the purpose of Regulation 7.4 is essentially only to backstop Regulation 7.2, that would, of course, only be the purpose of the provision, not its meaning. You would still have to give meaning to the language. Purpose can inform meaning, but in order to decide the meaning, you have to look at the words used. Obviously viewed in context, etc., tested by reference to absurd outcomes. I accept all of that. So, my lords, even if my learned friends were correct, that the purpose of Regulation 7.4 is to plug the gap, one does have to go further and look at what it means and construe the language. And we respectfully submit that it is notable that the learned judge did not anywhere do that, nor with respect to my learned friends. Indeed, my lords, while it is clear from her judgment what the learned judge thinks Regulation 7.4 doesn't mean, it is not clear what the learned judge thought it does mean. Now, so far as concern my learned friends, the closest they come to advancing any positive case about what Regulation 7.4 means involves the suggestion, and this is at paragraph 110 of their skeleton, which is at page 130, that Regulation 7.4 applies where a designated person has what they describe, again this phrase, as effective personal ownership, effective personal control over a company in circumstances where the situation doesn't fall within 7.2. And it appears to be this effective personal control, whatever that means, that is for my learned friends, the touchstone of Regulation 7.4. Can I just make a few points on that, if I may? First, this with respect amounts to a rewriting rather than a construing of Regulation 7.4 by inserting the word personal into the provision to qualify control. Second, it is with respect not entirely clear what my learned friends suggest in this context personal control actually means and how it differs from other kinds of control. Your lordships will note that my learned friends don't anywhere define personal control, but they do give an example of it, which your lordships will see at paragraph 110.1 of their skeleton. Your lordships see that, paragraph page 131. The example they give is of a discretionary trust established by a designated person. And in this example, this discretionary trust owns various companies, which in turn own underlying assets. And the designated person in this example does not have any ownership interest in the companies, but has effective control over them, and is able to cause their affairs to be conducted in accordance with his wishes. And your lordships may wish to note that the learned judge adopted this example in paragraph 237 of the judgment at page 192. Just pausing there, as your lordships will appreciate, it's an important feature of this example that my learned friends offer, that the control exists independently of any ownership, whether direct or indirect. That's the point that they're trying to prove. They're trying to capture a situation where control exists independently of any ownership, direct or indirect. Because, as I say, it's supposed to explain why Regulation 7.4 is required, in addition to Regulation 7.2. This is the gap, or the stop it's intended to back, or the gap it's intended to plug in 7.2, which is all about ownership. But my lords, once one accepts, as even my learned friends apparently have to, that Regulation 7.4 can apply in the absence of any ownership link, the concept of personal control becomes, we respectfully submit, meaningless, because one form of non-ownership control is not any more or less personal than any other form of non-ownership control. In all of these cases, the designated person has, by whatever means, which is the language used in 7.4, control over something that he does not own. There is nothing more to it than that. So that is my first point about my learned friend's attempt to characterise Regulation 7.4 as a gap-filling provision. Moreover, my lords, and this is our second point, insofar as this characterisation depends upon the discretionary trust or similar examples, below, before the learned judge, my learned friend characterised this or described this as being an apposite to describe the way in which wealthy Russians often arrange their affairs. But with respect, that is irrelevant. Your lordships find exactly the same language in sanctions regulations, not just in Russian sanctions, but sanctions regulations which apply to ISIL and Al-Qaeda. Now, it may well be that Russians like to arrange their affairs using discretionary trusts. But with respect, I'm not sure that the same, I don't want to give evidence here.
But it doesn't matter, does it, Mr. It's because the truth is that Mr. Pillow may be perfectly right that this is one species of non-ownership control, but it begs the question as to what other species of non-ownership control there might be.
Exactly, and why would someone in the ISIL Al-Qaeda scenario decide they wanted to catch discretionary trusts and not any other form of control? That's really our point. And my lords, as I say, in the context of a terrorist organisation, confining Regulation 7.4 to discretionary trusts and the like makes no sense at all. Those structures are used by businessmen, not terrorists, and the fact that the draftsman chose to employ the same definition of control for all of them is a powerful indication that what the draftsman was concerned with was the practical ability to exercise control by whatever means that is done. And that is no doubt why the words by whatever means were used by the draftsman. Now, third, and in any event, my lords, even just looking at the Russia regulations, we submit that there is nothing in the language of Regulation 7.4 that suggests that it is somehow ancillary to Regulation 7.2, or intended only to plug the gap left by Regulation 7.2. It is rather plain, we say, that Regulation 7.4 constitutes a further and independent limb of the control test. And just on that, perhaps I can just show your lordship's one authority, which is the HTTS case, which makes it clear that the control test, now in Regulation 7.4, may be satisfied even if control arises by virtue of something other than ownership, and that the test is purely factual. Does the designated person have the ability to call the shots? The source of the control doesn't matter. Your lordships will find the HTT case at volume 10, tab 47, page 3137. Now, in this case, a German shipping company called HTTS had been listed as a sanctioned company by the EU on the basis that it was owned or controlled by an Iranian company called IRISL. And HTTS subsequently brought a claim for damages against the Commission on the basis that there were no grounds for its having been listed and no basis for saying that it was controlled by IRISL. That claim was dismissed by the Council, and an appeal to the General Court was also dismissed. The matter was then appealed to the Grand Chamber, which sealed this at paragraph 3, which sets out the background. That's at page 3138. One of the issues arising was whether there had been any real ground for the inclusion of HTTS in the sanctions list in the first place, on the basis that it was controlled by a sanctioned company. And perhaps I can just invite your lordship to glance at paragraph 13, page 3140, where one sees what the General Court said about this and the factual context in which the issue arose. So, thus, in the context of the examination of the relevant matters in order to establish whether the acts of inclusion of HTTS in the list of at issue could be regarded as a flagrant and inexcusable breaches or manifest errors of assessment on the part of the Council, so far as concerns the nature of the links between HTTS and the other Iranian shipping companies, the General Court stated in paragraph 55 to 60 of the judgment under appeal that what is contemplated by the concept of a company owned or controlled by another entity is a situation in which a natural legal person involved in the nuclear proliferation activity of the state in question is able to influence the commercial decisions of an undertaking with which it has a commercial relationship, even in the absence of any legal tie between the two economic entities, or any link in terms of ownership or equity participation. In that regard, the General Court recalled the case law according to which the question whether an entity is owned or controlled must be assessed on a case-by-case basis by reference inter alia to the degree to which the entity concerned is owned or controlled. In the case in point, the General Court held that the evidence relied on by the Council, in particular, the fact that the Director of HTTS previously carried out the functions of legal Director of IRISL, and that HTTS had the same address as IRISL, amounted to a set of indicia that were sufficiently precise and consistent for it to be concluded that it was at least plausible that HTTS was controlled by and or was acting on behalf of IRISL. And this, as your Lordship sees, has nothing to do with ownership. It was to do with the fact that a director of HTTS had been a director of IRISL, and HTTS had the same address as one of the IRISL companies. If I can invite your Lordships next to go to paragraph 69 of this judgment, page 3147. I can just read 69. The use by regulation of the terms owned and controlled reflects the need to enable the Council to adopt effective measures against all persons, entities or bodies linked to companies involved in nuclear proliferation. It follows that ownership or control may be direct or indirect. If that link has to be established solely on the basis of the direct ownership or control of those persons, the measures could be circumvented by numerous contractual or de facto possibilities of control, possibilities which would confer on a company opportunities to exert influence over other entities that are as extensive as in the case of direct ownership or control. So the point of these wider provisions is an anti-circumvention purpose, and I'll come back to that. Just picking it up at 71, in paragraph 56 of the judgment under appeal, the General Court held that in the context of assessing the legality of a restrictive measure, what is contemplated by that concept is a situation in which the natural or legal persons involved in nuclear proliferation is able to influence the commercial decisions of another person with which it has a commercial relationship, even in the absence of any legal tie between the two economic entities, or any link in terms of ownership or equity participation. The complaint raised by the complainant appellant against that paragraph of the judgment under appeal is based on a misreading thereof. As the Advocate General has observed in point 39 of his opinion, it does not follow from paragraph 56 of the judgment under appeal that the General Court took no account whatsoever of the existence of any legal tie between HTTS and IRISL, or any link in terms of ownership or equity participation, but only that the absence of such a tie or link was not sufficient to rule out classification as an owned or controlled entity. In other words, the General Court held that whilst the existence of a legal tie or a link in terms of ownership or equity participation in a company may in certain circumstances result in the ability to influence the decision of the owned or controlled entity, it is not a sine qua non for the exertion of such influence. In the light of the foregoing, it must be held that the General Court did not err in law when it held that a company may be classified as a company owned or controlled by another entity, where the latter is in a situation in which it is able to influence the decisions of the company concerned, even in the absence of any legal tie between the two economic entities, or any link in terms of ownership or equity participation. My Lords, if ownership were all about, if control were all about ownership, as my learned friend suggests, then a practical ability to influence the affairs of an entity absent ownership would not be relevant, and this decision would not have been what it was. So that's what I wanted to say at this stage about the language of Regulation 7. Can I turn next to the political office carve-out, which the learned judge tentatively found to exist in the regulation. My Lords, we respectfully submit that there are at least 3 reasons why this is incorrect. First, it is contrary to the language and structure of the regulations. I'll just identify the reasons. Secondly, it is unworkable in practice. And thirdly, it is inconsistent with the rationale for the control provisions. What I'm proposing to do, subject to your Lordships, is to deal with each of those points and then to address certain further reasons given by my learned friends in support of the learned judge's conclusion. I have in mind the presumption against doubtful penalisation, and the supposedly absurd consequences to which our construction gives rise. But first, turning to the language and structure point, we have a number of points about this, but I can take them shortly, since I've made a number of them already. First, as your lordships have seen, there is no wording at all in any of the relevant regulations themselves, that is regulations 11 to 15, regulation 7, or in schedule 1, which addresses regulation 7.2, which provides any support for the limitation the learned judge with respect read into the statutory scheme concerning the capacity in which the designated person exercises control. Put differently, the learned judge's interpretation in fact involves rewriting regulation 7 by adding a proviso that control exercised by virtue of a political office held by an individual is to be disregarded. Secondly, as I've already submitted, the learned friends accept that regulation 7 does catch control exercised by virtue of something other than ownership. So they accept that non-ownership control counts, but there is nothing in the language that distinguishes between different forms of non-ownership control. To put it another way, if the language of regulation 7.4 is apt to catch a designated person who calls the shots at a discretionary trust that he does not own, or at companies he does not own, or through the fact that there is a commercial relationship in existence, it is with respect impossible to see why the language of regulation 7.4 is not also apt to catch a designated person who calls the shots in any other way, for example, by virtue of holding a religious office, or a political office, or perhaps by virtue of being incredibly well armed and dangerous, with great influence and power. It is the fact that that person calls the shots, or can call the shots, that is what triggers 7.4. Irrespective of how he, they, it, she does it. It's the outcome rather than the mechanism. Thirdly, there are various provisions in the regulations which we would submit are positively inconsistent with the political carve-out suggestion. Can I just give your lordships one example? Regulation 6.62b. So that is volume 4, tab 16, page 907. 6.2b, Secretary of State may designate a person under Regulation 5, and then in this regulation, an involved person means a person who is owned or controlled directly or indirectly within the meaning of Regulation 7 by a person who is or has been so involved. So one of the grounds for designating an entity is that it is owned or controlled directly or indirectly by a designated person. If the learned judge is correct, the Secretary of State cannot designate someone on this ground without asking themselves whether the control that the designated person has over them is by virtue of political office, because then it doesn't count, or by virtue of something else, because then it may. As your lordships will appreciate, designation criteria must be clear, because it must be possible both for the Secretary of State and the court in any challenge to the designation decision to determine what the designation criteria are. If a distinction between control by virtue of political office and any other kinds of control had been intended to form part of the designation criteria, one would expect this to be set out expressly in Regulation 6.2b, but it isn't, which suggests we respectfully submit that no such distinction was intended. Now, I've made this point by reference to Regulation 6, but it also arises in relation to other provisions in the regulations, which we say are inconsistent with the political office carve-out adopted by the learned judge. I'm not going to go through them. In the interest of time, can I just identify for your lordship's reference two of them? First, Regulation 11.6b, that's at page 917 to 8, and second, Schedule 1, paragraph 12 at 1056. So, my lords, we respectfully submit that if the learned judge is right, the court would have to rewrite not only Regulation 7.4, but also these various other provisions, including Regulation 6.2b. That's the first of our 3 points about the political office carve-out. That's the point about language and structure. Can I then move on to the point we make that the learned judge's carve-out produce an outcome which is unworkable in practice and would give rise to uncertainty? And we say that that is the position, my lords, because the carve-out, were it to exist, would give rise to 2 separate questions that the learned judge did not always identify, let alone distinguish, and they are these. First, what counts as a political office? And secondly, when does control arise out of that political office rather than out of something else? In other words, what causal or other connection is required between the office held by the designated person and the control that he has over the target entity? We respectfully submit that both of those are potentially difficult questions, and if they are relevant questions under the legislation, they would have required careful consideration and definition at the draft stage. Just in relation to the first question, what counts as a political office? My lords, we obviously accept that the office held by President Putin, in this case, is on any view a political office. But the answer will be less clear in other cases. For example, although my learned friends assert this is the case, does Ms. Nabiullina, the governor of the Russian Central Bank, hold political office? What about terrorist organizations such as Al-Qaeda, ISIL? Osama bin Laden, who headed Al-Qaeda. Perhaps he was the most powerful warlord. Is that a political office, or is that some other kind of control, if exercised by him? The difficulty of classifying particular posts held by terrorists and others as political or otherwise is, I would submit, obvious. The second question that would arise involves, as I identified earlier, the issue of causal connection. Plainly, a person who holds an office, whether political, corporate, or religious, or anything else, may have some powers that derive from that office, but some powers that derive from something else, such as a different office, or some personal relationship, or perhaps a relationship that arises by virtue of an important business connection or arrangement, or the ownership of some property. If the carve-out applies only to control exercised by virtue of a political office, then the court would have to embark upon an analysis of the different sources of control that a designated person has over a target entity, and exclude only the political office control in applying Regulation 7.
Is that a very plausible scenario, that somebody has a political source of power and something else?
We'll take, I'm going to come back to this more than once, but take the leaders of Al-Qaeda. Is that a political office, or isn't it? Or is it partly a political office, partly a religious office? And insofar as they exercise control, do they exercise control by virtue of holding that office, or by virtue of controlling a lot of people with a lot of guns, political or otherwise? And if the source of the control is more than one of those, how does one decide how you attribute what control they have to political office, i.e. the fact that he's the leader of Al-Qaeda, as opposed to, I don't know, religious office? So there's
one might posit an oligarch who is also the governor of a region in the Far East of the Soviet Union.
Indeed. I know who your lordship has in mind. Exactly that. Very good play about it. It does become...
That's not your best submission.
But it does get complicated, and if these complications were contemplated, one would expect at least some guidance in the regulations. But there's nothing. In my respectful submission, that's indicates that this just was not intended. It would require very careful legislation. Yeah. So I mean, I've got in my notes the Osama bin Laden, Ayman al-Zawahiri, who were the emirs of Al-Qaeda. They were given the title Emir. Is that a political office? I don't know. But if it is, it's associated with some religious position, with being in control of a lot of... And do they exercise their control because of their political office, or because they control a lot of people with guns?
And I suppose one possibility were we in this territory would be to say a religious office doesn't count either.
Well, indeed, you could carve out all control from all offices, which would be an even bigger carve-out than the learned judge has gone. And in a sense, the learned judge rejects my learned friend's submission of corporate office. There's a reason why, because it's contrary to authority. But even that wouldn't be enough. One would have to take out any control of any, by virtue of any office. And with respect, there's no basis for that in the legislation. In the end, my lord, with respect, it doesn't matter whether someone controls what another company... Let me give you, if I can, an example. Let's take the Wagner Group, who have recently been designated, a paramilitary or military organization. The people who have been designated, not the group, two individuals have been designated. Dmitry Utkin, who's the commander of the Wagner Group, that's his title, and someone called Andrei Nikolaevich, who's the chief executive of the Wagner Group. Now, undoubtedly, those sanctioned individuals can exercise control over companies and assets, certainly within their sphere of influence in maybe parts of Ukraine, parts of Russia, maybe now parts of Belarus, who knows. And they can control those other companies and entities by virtue of positions they hold in Wagner Group. And they can ensure through that, possibly by force and intimidation, that the companies within the entity, the areas that they control, do what they are told to do. So there's a company which, for example, can buy arms, or a company which can trade forex on the market. Mr. Dmitry Utkin is interested in that, and he doesn't do it himself, but he gets some company somewhere in Ukraine to do it by, who knows, by virtue of making threats or something. Plainly exercises control by virtue of him holding that office. Is that to be excluded? Because if it is, in our respectful submission, it drives a coach and horses through these sanctions regulations. And that's why we respectfully submit. What matters is identifying who calls the shots. It doesn't matter how they call the shots. It's controlled by whatever means. That's what the statute says. Even, let's just take President Putin, who's not only topical but relevant to this particular application, because he is the designated person who he says has control. It's been reported in the press, I'm not giving evidence or inviting your lordships to make findings about this, but it's reported in the press that President Putin is worth, it doesn't really matter, but I'll give a figure of $200 billion, that he owns a mansion in the Black Sea worth $1.4 billion, that he has several hundred cars, luxury watches, and so on. Now, if it were true that one would have to distinguish between the assets that he controls or owns by virtue of political office from personal control, you would have to identify in relation to all of those assets whether he acquires them or controls them by virtue of being president, or insofar as this is distinguishable, personally, because someone thought they should give Vladimir Putin something. With respect, the difficulties this creates are creating an unworkable situation, which is the only submission I'm making at this stage about the learned judge's suggestion. I'm not sure I need to...
What's said against you is that, in a sense, this becomes the logical consequences that he controls absolutely everything there is in Russia, every company.
Indeed, and that's a serious point which I'm going to have to come on and address, because in my respectful submission...
You may be right, you may be wrong, but
that's the consequence.
Seems to me to at least be an arguable consequence.
Well, perhaps I can... And my learned friends are not wrong to say that in the situation in which we find ourselves, one could definitely make that argument that given President Putin, given the power he exercises, given the fact that he's been designated, the possibilities of this applying to any Russian company arise. And can that really have been intended? But with respect, that goes back to one of the first points I made, about not confusing what the regulations mean on day one with what has happened subsequently as a result of decisions made by the government. Now, what has happened is the government, subsequent to these regulations being passed, designated President Putin, possibly without having regard to the fact that Russia is a command economy in which my learned friends appear to accept President Putin can control everything, and that one possible consequence of the government's decision to designate is that you produce this outcome. But with respect, that doesn't mean that our interpretation of the regulations is wrong.
No.
It just means that as a result of two factors and our interpretation, I accept it couldn't happen without our interpretation, the government, when it designated President Putin, may not have appreciated the consequences of what it was doing.
It's right, is it, that supposing that you designated a member of a conventional legislature, none of this could apply because an individual could not individually control anything.
I can't say any individual ever that would be true, but yes, I would respectfully submit that that's like, if control arises, it will arise by virtue of other things in addition to the political office. But
So
I
it
can't
has to
imagine
be an individual who has
happens to have
individually on his own that degree of control.
exactly, and that is a rare occurrence. And the evidence which my learned friends in the end decided not to oppose, no doubt with a view to be able to make the point that they're making here, was that because Russia is a command economy, there's very interesting evidence from very knowledgeable people about the way in which Russia works, where you have some industries which are cash generating and other industries which are critical, who don't generate cash. What you really need to do in a command economy is to ensure money goes from the cash generating industries to the important industries like military. In order to be able to do that, you need a command control type economy where someone says, you, the oligarchs in charge of energy, build me something for the Winter Olympics, or transfer money to some industries which need it. And it gets done because there's one person who certainly calls the shots there. But that is rare.
Well, these are 2019 regulations aimed at Russia, I think.
But
At
the
that
language
stage,
is exactly
everybody
the
knew what Russia was like, surely.
Well, it may be that they did, and they didn't understand the effect of the designation. My lord, the argument we're having now has not been had before in any courts. So other than HTTS, and I'll show your lordship some guidance on other things, but the particular argument we're having now has not been had.
No, I understand
So-
that,
so
but you seem
it's
to be
perfect.
suggesting, well, Russia is of a particular type, but these are Russian sanctions.
I'm not disputing that. The language is the same in all other sanctions regulations. My only point is it's perfectly possible. My interpretation of the regulations, it doesn't follow that they're wrong, because by virtue of a decision subsequently made by the government to designate President Putin, you have a particular outcome in circumstances where he holds a particularly, I can't say unique, but it's a very unusual position as at the apex of a command economy where my learned friends accept, whether they've just accepted for forensic reasons or otherwise, that he can control just about anything he wants to control. But it doesn't follow going backwards. It doesn't prove my interpretation is wrong
No, I understand.
or even absurd. What has happened is a decision has been made by governments where they may not have understood the consequences of that decision. And I accept there is a problem that arises if I'm right, because someone may want to look again at exactly what consequences they want to happen. But again, that's not a reason for not interpreting it according to the meaning that the language has viewed in context. One can't backwards engineer. And that, in a sense, deals with
But if you're right about your control, that control means, as you put it, calling the shots, then that's one of the consequences may be the one that Mr. Pillow identifies.
Indeed. And
But I mean, one
If it's
sense
absurd.
it's difficult to see. In one sense, if one looks at what's really happening with many discretionary trusts, that those are examples of somebody who isn't a beneficiary of the trust, but who calls the shots, really.
exactly. And that's why we say once you accept the discretionary trust non-ownership situation,
It's not legal control.
no, it's not legal.
It's effectively an influence
And that's what your lordship will recall, I think it is paragraph 9.3d says, you're able to influence.
Yeah.
So we accept that this has this consequence which looks startling. Maybe we know that no lawyers are allowed to deal with Russian companies in a transactional sense. You know, maybe the government did intend this, but maybe it didn't. But to some extent, it doesn't matter. When I say intend by the designation that this should happen. What matters here is what the legislature intended when it used this language. And it may have a consequence which does need to be dealt with if this isn't what the government want to happen. But again, that just doesn't show in our respectful submission that our submission is wrong. Again, I had one other, I think it was our third ground of why the learned judge is wrong, and that's the anti-circumvention rationale. Because we say the carve-out is contrary to the rationale of the control test in Regulation 7.4. I showed your lordships the HTTS decision, paragraph 69, where the Grand Chamber explained that the concept of control was to prevent circumvention of the sanctions by designated persons. Again, that was volume 10, tab 47, page 3147. That rationale and objective is obviously intended to be carried through by Regulation 7, applying as it does to indirect and direct ownership and control by whatever means. And my lords, the political office carve-out is, we would suggest, contrary to the anti-circumvention rationale, because an individual designated person who holds an office of state could use that office to do things he's prohibited from doing. For example, to buy an expensive car for his personal use. And that is also likely to be particularly so in a jurisdiction like Russia, where it might be said that the distinction between personally held assets and assets held by virtue of someone's office, going back to governors of particular provinces, is somewhat elusive. We would submit, my lords, that any interpretation of those provisions which undercuts that rationale, in particular any such interpretation that finds no support in the language of those provisions, is unlikely to be correct. So those are the three reasons that we give as to why the political carve-out doesn't work. Can I just deal with my learned friend's respondents' notice point, where they try and expand the carve-out still further, but only to include corporate carve-outs. This is an argument rejected by the learned judge in her judgment, no doubt, in part at least, because it was too extreme and also found no support in the language. And it therefore comes before your lordships as a respondent's notice point. The claimants say not only political office is to be regarded, but also corporate office to be regarded. Now, we submit that this suffers from all the same problems that afflict the learned judge's political control carve-out. In particular, I'm not going to repeat them all, but just identify, there is also here no language anywhere from which it can be derived. And indeed, I would respectfully suggest that it is flatly inconsistent with the words by whatever means. And it cuts even more against the anti-circumvention rationale. The wider you make the carve-out, the less the anti-circumvention rationale is served. For good measure, my lords, my learned friend's suggestion is also contrary to EU authority and guidance. And can I just show your lordship that? Can I invite your lordships first to go to a European Union Commission opinion dated the 8th of June 2021. You have that in volume 16, tab 111, page 5088. 5088, yeah. So, as your lordship sees, this is a commission, EU Commission opinion, and if you go to the first, you can see on the cover, it's an opinion on Article 2.2 of Council Regulation. If you go to the following page, your lordship sees there's an explanation as to how this opinion came to be.
Page you on, Mr.
Sorry, page 5089, I'm so sorry.
Yeah.
Looking at the first request, just again, The learned friend's case, of course, is that nothing has changed since the EU regulations and we're in the same position. And that's why this is obviously relevant. If your lordships just look at first requests, sort of 3/4 of the way down the first page, one designated person listed in Annex 2 to the regulation is the chairman of the board of directors of a non-designated non-EU entity. According to the NCA and based on the statute of Entity A, this management role makes the designated person responsible for organising the work of the board of Entity A and ensuring the successful fulfilment of tasks of the board by its members. In turn, Entity A owns a subsidiary company based in an EU member state. So you've got someone who is the chairman of the board of a non-designated company, but by virtue of that, by virtue of that management role, he exercises control over the board of Entity A and the fulfilment of its tasks. And then, as your lordships see, the question that arose was whether the chairman of the board of a non-designated entity could be said to own or control that entity within the meaning of the EU sanctions regulation, such that the entity was also subject to sanctions. So he was subject to sanctions. Was the entity over which he exercised management control, that's to say control by virtue of his corporate position, also subject to sanctions? And we do highlight the fact that it was the management control that was being focused on here, management role that is being focused on here. The EU Commission concluded that the control he had over the non-designated entity through his office as the chairman of the board was relevant. If you want to go to page 5091, the NCA, I should probably start just at 509A. Your Lordship sees, under first request, the Commission has previously identified a number of criteria which should be taken into account to determine whether a legal entity is controlled by another person or entity. That's to say whether that is able to effectively assert a decisive influence over the conduct of the entity of the entity in question. The criteria are as follows. The Lordships may want to have regard in particular to D, having influence as regards corporate strategy, operational policy, business plans, investment capacity, provision of finance, human resources and legal matters. And then over the page, in the Commission's view, if the designated person is determined to have control of the entity, A, it can be presumed that the control extends to all assets nominally owned by the latter. Then the NCA is competent to factually determine whether the elements that it has identified as linking the designated person to entity A amount to meeting any of these criteria or others, which may prove that the designated person has control over entity A. This determination should be made in light of the above clarifications, taking into account all the elements at the NCA's disposal and the specific circumstances of the case. Now, my lords, virtually anything the learned friends have to say about the EU guidance is that it is not binding on this court. That's a paragraph 117.2 of their skeleton. And my lord, we respectfully agree with that. It is not binding on the courts. But my lords, binding or not, this does, as was intended, provide reasoned guidance about what the concept of control means under the EU regime. And my learned friends do not suggest that the concept means anything different under the UK regime. Indeed, their case, as I've said, is very much that the two are aligned. My lords, what is perhaps very striking also about the guidance, which raises squarely cases where control is exercised by someone holding corporate office, is that nowhere is it suggested in any way that there is some unstated carve-out for cases where control is exercised through holding corporate office. In addition to the guidance, there is also EU authority that shows that control exercised through a corporate office is relevant. Can I just give your lordships a reference to this and deal with it if I need to in reply? The case is one called Syriatel, Syria as in the country and then tel as in telecommunications. It's at volume 15, tab 99, page 4786. It's really paragraphs 94 and 95. And there is another case, which again, if I can just give your lordships the reference, it's the Al-Dulimi case, Al and then D-U-L-I-M-I, at volume 8, tab 24, page 2308. And that was a case in which a company called Montana Management Inc. was designated on the ground that its managing director, a Mr. Al-Dulimi, was associated with the Iraqi Secret Services. So, managing director associated with the Iraqi Secret Service, enough to make you designated. Again, the question of corporate control was not argued. No one said, isn't there a carve-out for corporate control? And then the court rejected it. It simply doesn't arise. So, my lords, we respectfully submit that the corporate control carve-out doesn't fare any better than the political office carve-out. Can I just then finally, I think, deal with some further reasons given by the judge and indeed my learned friends in support of the carve-out. And first, this is a point that my learned friends raise, I think the learned judge didn't go for this, is the presumption against doubtful penalisation. The learned judge refers to that at paragraph 234 and following, and we deal with this in our skeleton at paragraph 123 and following. As your lordships know, this concerns in essence the principle that penal legislation is to be construed strictly. And again, I would make it clear immediately that we don't dispute the existence of a principle against doubtful penalisation. And although the learned judge also referred in the judgment, paragraph 222, to Article 7, it is well established that this doesn't add anything to the common law, and I wasn't proposing to deal with that separately from the common law. Just for your lordship's note, the authority for that proposition, that Article 7 doesn't add anything to the common law, is the MISRA case, M-I-S-R-A, referred to by the judge at paragraph 226. That's at volume 14, tab 82, page 4333, paragraph 32. Now, my lords, it isn't entirely clear what the learned judge actually made of the presumption against doubtful penalisation between paragraphs 234 and 236. But we submit that there are three reasons why it doesn't support the political office carve-out adopted by the learned judge. First, the presumption is not engaged unless there is uncertainty in the elements of the criminal offence, as distinct from uncertainty as to the outcome of individual cases concerning the elements, concerning that offence. So there has to be uncertainty about the elements of the criminal offence. And for that, can I just refer your lordship, perhaps I can just share this to your lordship. It is in the MISRA case, which volume 14, tab 82, page 4344. Paragraph 63. On examination, this represents one example among many of problems which juries are expected to deal with, address on a daily basis. They include equally difficult questions such as whether the defendant has acted dishonestly by reference to contemporary standards, or whether he has acted in reasonable self-defense, or when charged with causing death by dangerous driving, whether the standards of his driving fell far below what should be expected of a competent and careful driver. These examples represent commonplace for juries. Each of these questions could be said to be vague and uncertain. If you made inquiries in advance, at most an individual would be told the principle of law which the jury would be directed to apply. He could not be advised what a jury would think of the individual case and how it would be decided. That involves an element of uncertainty about the outcome of the decision-making process, but not unacceptable uncertainty about the offence itself. So the focus is on the offence itself. And what my learned friends have to demonstrate in order to invoke this presumption is that the offence itself becomes uncertain on our construction, and indeed one assumes that it is any clearer on their construction. And we submit that they cannot do that because on our construction of Regulation 7, the meaning of control is clear. Indeed, clearer than the meaning of many of the concepts to which Lord Justice Judge referred in paragraph 63, which Lord Justice Judge said was not uncertain. Secondly, even in relation to the elements of an offence, the presumption only applies if there is genuine ambiguity going beyond disagreement about what the words mean. For your Lordship's note, that is what the House of Lords said in the Attorney General reference case, volume 8 of the Authorities Bundle, tab 23, page 2303 between C and F, in the speech of Lord Lowry, referring to what Lord Reed said in the earlier Popplewell case. And that's reflected in the learned judge's judgment at paragraph 234. But having accepted that, the learned judge did not anywhere identify which words in Regulation 7 are even uncertain, or what the ambiguity is said to be. It's not really clear what the presumption against doubtful criminality applied to in terms of the language. We say, for reasons I've already given, that there is no ambiguity in the meaning of Regulation 7 that could justify reliance on the presumption. Thirdly, in a way this is the most important point, my Lord, the construction of Regulation 7 that my learned friends invite your Lordships to adopt would, if anything, give rise to much greater uncertainty, or certainly as much uncertainty as our construction. It is not, therefore, a construction that the presumption against doubtful penalisation could justify adopting, because adopting it would not resolve uncertainty, it would produce uncertainty. For one thing, my lords, one would need not only to look at the words of Regulation 7, but also at an implied qualification carving out control by virtue of political office, which nowhere appears in the language of the regulation. And in addition, one would then need to ask whether the office in question is a political office or some other kind of office, and whether the particular power that the designated person has arises by virtue of political office or by virtue of something else, such as his personal status. We respectfully submit that it's impossible to see how adopting this construction could ever be justified by a desire to avoid uncertainty. And my Lord, the only other point I think I needed to deal with was the absurd consequences point. And I think to a very large extent I have addressed that with your Lordships already. That is the point about, well, if we're right and President Putin controls all companies, look where it lands you.
Yeah.
The problem about that, as I say, is not with our interpretation, it's with the designation subsequently of President Putin in a very almost unique situation where he's the apex of a command economy, and my learned friends accept this, as I say, probably for forensic reason, has the ability to control any entity in Russia. But that doesn't mean our interpretation is wrong. My Lords, I'm sorry it's taken a while, but subject to your Lordships, those are our opening submissions, unless I can assist your Lordship.
No, thank you very much indeed, Mr. Superintendent. We'll take a break now then.
that's right.
You'll find out.
No, not really. It's quite important. Why don't you say that that's in the record? I do think where it's not designated. It might not be easy. Everyone thinks it is easy. Everyone thinks it's easy. Control. Any transaction control May it please the court. We're going to go back to the beginning, I'm afraid, and I'm going to argue the points in the same order that Mr. Rabinovitz dealt with them. I'm going to deal with the question of entering judgment and the correct interpretation of the licensing provisions under the regulations from Samler. My learned friend Mr. Davis will then deal, as he dealt below, with the issue of control and the article, the regulation 7 points that Mr. Rabinovitz just finished with. We're clearly not going to get onto that for a little while. Can I start with a few introductory words about the importance of the right of access to the court? I know the court, in general terms, is familiar with it, but in my respectful submission, it's the correct starting point for understanding what it is that may make inroads into that right and whether these statutes and statutory instruments have done so. The right of access to the court in this country, where we have the rule of law, is a constitutional and fundamental right recognised by the common law for centuries. And my lords, it's not a right limited to the determination of a valid claim, as I'll show you. And this is rather fundamental, perhaps, to the analysis that one applies. The constitutional and fundamental common law right applies
to any arguable claim you have that can properly be brought before the English courts, even if it turns out to be unsuccessful. And my learned friend's case, effectively, as you've heard, is that the effect of the 2019 regulations, is to require the court to mandate an indefinite stay immediately upon the issue by a designated person of a civil claim, presumptively arguable, including any claims that were issued before designation, in relation, of course, to obligations that arose long before that itself, all on the basis, it is said, that one ultimate objective of the claim, if it is successful, in several years' time, is to obtain an order for the payment of a sum of money in due course. And that, of course, in a few years' time, when that judgment putatively might or might not be entered, is a time when sanctions might or might not be different, or might not exist. But even if they are unchanged, and they remain in force as they do today, it would, on my learned friend's case, in any event, mean that any judgment that was entered in favour of a designated person could not in any event be satisfied in any way by anyone who is subject to the UK sanctions regime. Now, the question, therefore, is whether the 2019 regulations as a statutory instrument can possibly have had that effect. Because in my respectful submission, there can be no sensible dispute that if the combination of provisions my learned friend relies on does mandate an indefinite stay of a civil claim, there is obviously a prima facie denial of access to the court. So the question is whether SAMLA, the Act itself, the primary legislation, unambiguously authorised a claim commenced by a designated person before designation in relation to pre-designation obligations, or indeed required such a claim to be stayed indefinitely upon designation or immediately thereafter, even years before any possible monetary judgment is even considered by the court. And that in turn, my lords, raises the question of whether an immediate and indefinite stay of a civil claim in those circumstances represents the lowest level of interference in the fundamental right of access to the court that is authorised or required, if any is, by the primary legislation, or is implemented via intra vires by the regulations. Now, the answer to that second question, my lords, might be thought to be obvious. Even if the final entry of a money judgment under the present system of sanctions might not be allowed, and you know we say it is, but even if it weren't, it is obviously not the minimum level of interference in the access to the right of access to the court to impose an immediate and indefinite stay, because there are very many steps that can be taken up to and adjacent to the entry of an actual money judgment over the next 2, 3, 4, how many years it takes to get to a trial and a decision. So there can't be, in my respectful submission, any sensible submission that even if there is some authorised curtailment of the right of access to the court by the inability to enter a judgment given SAMLA, that the proposed course my learned friend relies on is the minimum required interference or authorised interference that would maximise the effect of the right. Now, in some ways, and this may go to my Lord Justice Popplewell's point this morning about discretion, but in some ways on that analysis, of course, the principal issue in this appeal could be somewhat academic, because even if it were to be the case in the relevant time, some 2.5 years or so or more away, that the sanctions then did prohibit the entry of a money judgment. Well, so what, one might ask? Why is the court being told that it is required now to stay the action indefinitely in any event? Because it wouldn't, even if that were right, prevent the trial court, in due course, from entering judgment for the claimants on liability, with quantum to follow, which is not something that's very unusual in the courts. Of course, you could have quantum dealt with in elaborate detail in a reasoned judgment, but still just not enter a judgment for on the quantum and confine the judgment to a judgment on liability, just as if there'd been a split trial. You could even have a split trial.
Would that leave it open to someone later to say there hasn't been an order, we can re-argue quantum?
No, my lord, because that would be that would be a determination of the matters that are the subject of the judgment.
Would it? If there's no order reflecting it?
There would be an order on that basis, my lord. The order would be that judgment be entered for the claimants on liability, and that order could be appealed.
Yes, but in relation, I think what you were positing was a judgment on liability and a reasoned judgment on quantum, but no order in relation to quantum.
Yes.
I was just
I see.
querying. I mean, it's the same point if you have a reasoned judgment without any order.
Yes, I take that point, my lord, and that's why one would get to the process and the trial court would decide whether it's appropriate to say anything about quantum or not in the order, in the reasoned judgment. But of course one could equally have a reasoned judgment and a judgment entered on liability with declarations as to the amount of harm that has been suffered on that basis by the claimant. Those declarations could be appealed. There would be no money judgment, there'd be no entry of judgment, there'd be nothing wrong with getting to that stage. And so that would clearly be an effective way to give access to the courts for the determination of civil rights and obligations, but it wouldn't engage any of the problems my learned friend posited with entering a judgment. I'll come back to what he says about how one might be using a cause of action, and that might at some stage during the trial or during the proceedings between issue and trial be prohibited by Regulation 11. There is nothing in that point in my submission.
The difficulty with that is the one that, as I see it anyway, is the one I identified with Mr. Ravinovitz during the course of the morning.
Yes.
Which is that if he's right about it, then throughout the proceedings, at every interlocutory hearing, there is a change in value of the cause of action, and therefore Regulation 11 takes effect, and therefore, on that hypothesis, the whole proceedings are illegal.
Yes.
If he's right.
I entirely endorse that, my lord. I'd go further, of course, because it's every raise of the judicial eyebrow that could have an effect on the value of a cause of action. There's obviously further points there, because in my respectful submission, Regulation 11 has nothing to say either about causes of action, in the sense that because they're not funds, and so Regulation 11 is confined to the question of what you can do with economic resources. There's also the question, though, that it's certainly got nothing to do with value of the putative shows in action, as the discussion we had, my Lord Justice Newey had earlier, because there's no mention of value. And values fluctuate all the time. If you've got an asset, the value might go up and down. Regulation 11 doesn't attempt to deal with that. It addresses something completely different. We'll come on to all of that. But my Lord, I'm trying to address, if you like, the hierarchy of points from that enable this court to give maximum effect to the constitutional right to access the court. Because the way my learned friend argues the case is that it's predominantly because you can't enter judgment for a money sum, but also because there might be problems with licensing costs. That means that the effect of those provisions in the sanctions have curtailed the right to such extent that a stay is required, is mandatory. And for the reasons my Lord the Chancellor said earlier, you cannot divorce, on his case, what the individual provision requires or prohibits from the effect he says it has on the ability of the court to do its job. Because his case is that those combination of those problems, as he would have it, means there must be a stay, and the door to the court must be slammed in our face now, when there are lots of ways in which we can vindicate, or the court can vindicate, our right of access and determine the claims. So I've mentioned judgment on liability. I've mentioned declarations more generally, declarations either on liability or on the breaches of the relevant Russian law provisions that we've invoked, declarations as to the harm suffered. They're all entirely possible, and we would seek to take advantage of that if we were required to. But can I just say, my lords, that there are already claims for declarations in this case. You've not seen this, but we only need to look quickly, perhaps, because these are claims that the defendants approached the appellant's approach, wouldn't affect at all in any event. They're in the core bundle, tab D, tab 13 in the pleading, to show you what there is. We haven't looked at this yet. Tab 13, and if one goes to paragraph 48 at page 221, please, my lords, you'll see that there is a claim for declarations to the effect of the matters set out in 46.2, and those matters are matters that the Russian court had declared and held, and the claim is as far as necessary for the same relief here. And there's a similar claim for declaratory relief in paragraph 50 over the page at 222, and those, my lords, are in respect of the Okriti transaction and what's called the Rostbank transaction, respectively. So to get to those declarations, of course, one would have to investigate the underlying facts and matters and work out whether the evidence established that the relevant Russian provisions had in fact been breached in the way the Russian court decided they had: abuse of rights, unequal consideration, invalidity of the relevant agreements, and so forth. And that would entail a trial of the facts. I don't understand my learned friend to say that that claim, so far as it's made in those through those declarations, would have to be stayed because it wouldn't have anything to do with entering judgment for money. And I'll leave aside again the regulation 11 point, which I'll come back to. And then there's a possibly slightly more familiar style of declaration claimed if your lordships go to page 249, please, of the bundle, paragraph 75, because one of the claims we make against Mr. Boris Mintz, who is D1.
Sorry, I wasn't keeping up. Which page?
Sorry, it's page 249 of the bundle.
Yeah.
One of the claims we make against D1 is for a declaration that the Cayman Islands Trust, of which he was the settlor, is in fact not a valid trust or not a genuine trust, or in any event that he is the true beneficial owner of the trust. And we put it in all sorts of other ways, of course, including alternatively under section, the relevant section of the Cayman law that mirrors 423 of the Insolvency Act in this country. So, and you'll see the prayer then picks that up at prayer paragraph 2, page 252. Really, that's just an example, though, my lords, of why on any analysis, if we were wrong on the judgment point, the stay would be an inappropriate remedy and cannot be required by the sanctions regime. I do say as well that nothing my learned friend said about judgment entry would prohibit the court from entering judgment conditionally upon the relevant defendant or the relevant claimant or claimants ceasing to be designated persons or controlled by designated persons. That would be an order that could be appealed, but it would not give rise to a judgment debt whilst the condition remained unsatisfied. That would be a vindication of the rights of the claimant and its rights of access to the court, and it would clearly represent a far lesser intrusion and curtailment of that right than an immediate and permanent or indefinite stay. And as I said, none of those approaches, I'll come back to, one can also impose a stay of execution, which would prevent a third party coming along having acquired the debt from trying to enforce it. One could do all sorts of other things, but for present purposes, all I'm trying to establish is that the constitutional right my clients have to access the court does not and cannot sensibly turn on whether there can be an entry of judgment in 3 or so years' time, 2 or 3 years' time. Now, one of the odd premises, of course, of my learned friend's application is that my client would succeed and otherwise be entitled to a money judgment. And your lordships might wonder why defendants who claim that they've done nothing wrong would make that assumption in a fraud case. But the reason, this is not just a forensic point. The premise of my learned friend's application for a stay now is it assumes that the claimant's claim can't be pursued because it would succeed and they will be awarded damages. But as I've said, the fundamental right of access to the court does not depend on assuming that we will succeed. It depends on assuming we have an arguable claim that people in this country can invoke the courts to decide. What if the defendants are successful? No one's suggesting there's any problem with entering a judgment in their favour at the end of trial. So if we have a clear, as I say we do, a clear constitutional right to have our arguable claim determined, it's not because it's bound to succeed, it's because it's properly arguable. And we know it's properly arguable because we've been through the process of getting the freezing orders and having the merits tested at the interlocutory stage on multiple occasions. So we're not even in one of those cases where there's never been a court assessing the arguability of the claim. There's no question in this case that the claims are arguable. They are in fact obviously good arguable cases because that's what the courts decided to impose freezing relief. And there is no suggestion that there is any jurisdictional or other problem with bringing the claim. So, my lords, you can't consider, in my respectful submission, the merits of the application for an immediate and indefinite stay on the basis that we can only have a legitimate and constitutionally protected right to proceed if we win. Simply not the way it works. So the question, as I said at the beginning, I'll now move on to in substance, is whether the legislature, in enacting the primary legislation, SAMLA, unambiguously authorised the curtailment of the fundamental right of access to the court through the words it used and the intent it had, even on the assumption that there might never be a point in time when the court is actually considering entering a monetary judgment in our favour, or in favour of a designated person, to put the problem in the abstract. Can I take your lordships first, and I hope briefly, just do a couple of cases on the common law right of access? Because if you're going to be asked to decide whether words displace the right, you've got, in my respectful submission, to fully embrace and understand quite how deep and fundamental the right is. It's the case of the Crown against the Lord Chancellor ex parte Witham in your authorities bundle at tab 79, please. And like my learned friend, I don't have the same bundles in volumes as your lordships. I'll give you the tab. I hope that's enough, and I'll try and work out.
79.
Yes, my lord.
Yes.
13.
This is Mrs Justice Laws.
This is Mr. Justice Laws. That's right, my lord. And the two cases I'm going to show you are cases about the imposition of court fees or the removal of a remission on court fees, because they clearly engaged the concept of access to the court. And in this case, this was a removal by the Lord Chancellor by an order made under his statutory powers to remove the right of remission of fees in certain cases. That's probably all your lordships need to know about it. What I'd like to take your lordships to is at page 4294, at letter E, please, where the judge says this: in the unwritten legal order of the British state, at a time when the common law continues to accord a legislative supremacy to Parliament, the notion of a constitutional right can, in my judgment, inhere only in this proposition, that the right in question cannot be abrogated by the state, save by specific provision in an act of Parliament, or by regulations whose vires in main legislation specifically confers the power to abrogate. General words will not suffice, and any such rights will be creatures of the common law, since their existence wouldn't be the consequence of the democratic political process, but will be logically prior to it. I shall explain in due course what I mean by a requirement of specific provision, a concept more elusive than it seems. Mr. Duffy, for the applicant, cited a number of authorities to support the proposition that access to the courts is a right of the kind such as I've sought to describe. Bremer Vulcan, he says, was a decision of their Lordship's House. Facts are far removed. But Lord Diplock said, and then he quotes, the High Court's power to dismiss a pending action for want of prosecution is but an instance of general power to control its own procedure so as to prevent its being used to achieve injustice. Such a power is inherent in its constitutional function as a court of justice. Every civilised system of government requires that the state should make available to all its citizens a means for the just and peaceful settlement of disputes between them as to their respective legal rights. This means the means provided are courts of justice to which every citizen has a constitutional right of access in the role of plaintiff to obtain the remedy to which he claims to be entitled in consequence of an alleged breach of his or her his legal or equitable rights by some other citizen or defendant. So that is House of Lords authority, if you like, for the constitutional nature of the right, cited there by Mr Justice Laws as he then was. If one goes over to 4298, please, a couple of pages further on, 585 of the report. Next to the letter D, my lords, you'll see that the judge says, as regards the ECHR jurisprudence, I will say only that, as it seems to me, the common law provides no lesser protection of the right of access to the Queen's courts than might be vindicated in Strasbourg. I just picked that up because, in my respectful submission, that's correct. Whatever Strasbourg says, the common law will give no lesser right. And that means that this constitutional principle is, in fact, the one at play for those purposes. The bottom of that paragraph, near F, he concludes, indeed, the right to a fair trial, which of necessity imports the right of access to the court, is as near to an absolute right as any which I can envisage. It seems to me, from all the authorities to which I referred, that the common law has clearly given special weight to the citizen's right of access to the courts. It's been described as a constitutional right, though the cases don't explain what that means. In this whole argument, nothing to my mind has been shown to displace the proposition that the executive cannot in law abrogate the right of access to justice unless it is specifically so permitted by Parliament. And that this is the meaning of the constitutional right. But I must explain, as I've indicated I would, what in my view the law requires by such a permission. And this is moving on to the construction part of the substance. A statute may give the permission expressly. In that case, it would provide in terms that in defined circumstances, the citizen may not enter the court door. He then refers to ex parte leach, where the Court of Appeal accepted, as in its view, the ratio of the House of Lords decision and Raymond Honey vouchsafed, over the page, please, that it could also be done by necessary implication. However, he says, for my part, I find great difficulty in conceiving a form of words capable of making it plain beyond doubt to the statute's reader that the provision in question prevents him going to court, for that is what would be required, save in a case where that is expressly stated. The class of cases where it could be done by necessary implication is, I venture to think, a class with no members. And finally, below, near F, please, from the third line of that paragraph, it is that the common law affords no special status whatever. Sorry, the losing party's argument contains an unspoken premise. It is that the common law affords no special status whatsoever to the citizen's right of access to justice. He says that the statute's words are unambiguous, or amply wide enough to allow what has been done, and there is no available Wensbury complaint. That submission would be good in a context which does not touch fundamental constitutional rights, but I do not think it can run here. Access to the courts is a constitutional right. It can only be denied by the government if it persuades Parliament to pass legislation which specifically, in effect, by express provision, so in other words, specifically he's equating with express provision, permits the executive to turn people away from the court door. This has not been done in this case. Now, of course, my lords, in that case, the relevant statutory instrument or order and the relevant empowering statute, which was the 1981 Act, section 130, I think, at least had something explicitly to say about access to the court, because it was the specific provision in the statute authorising the Lord Chancellor to impose or remit fees for accessing court. And the power in the Act gave the Lord Chancellor, on its face, untrammelled, unambiguous powers to impose or remit such fees as he wished. But even when the statutory instrument addresses access to the court and the constitutional right to do it, as this case shows, and the Unison case I'm going to come on to shows, even express unambiguous words don't confer the vires needed to curtail or impinge on the constitutional right of access if it's not specifically said by the statute that Parliament is intending to authorise it. And of course, the comparison in our case is with two statutes that do not mention, as I'll come on to show you, the right of access to the civil court for the determination of civil rights and liabilities. The only place in which it does, in fact, is a way in which I would say just helps me, and I'll show you section 44 in due course. But can I then ask you just to look at the other case I wanted to show you on this, which is Unison, the Crown on the ex parte Unison against the Lord Chancellor. And that's at tab 77 of, I think, the same bundle.
Yeah.
Page 4220 it begins. And of course, it's a similar topic. One has the employment tribunal fees being introduced in 2007 or 6 by the Lord Chancellor as a political decision by order made under section 42 of the Tribunals, Courts and Enforcement Act 2007, which empowered him specifically and with no restrictions to impose such fees on all tribunals. Again, one has a statute that does have explicitly something to say about access to the court, and one has a power that is untrammelled and unambiguous in its words, giving the Lord Chancellor the right to set the toll, if you like, at the gate of the court. And the key points here, as you know, the decision was that the order was ultra vires, and because it impinged on the right of access to the court, amongst other things. If you go, please, to paragraph 29 of Lord Reed's judgment for the majority in that case, it's 4239, my lords. I won't burden the court with all of this, but you'll remember, I hope, that Lord Reed, I'll show you a little bit of it, gives an important and comprehensive overview of the rule of law as it applies to access to the courts and the interplay between the two. I just want to pick up paragraph 29 at the beginning. It's on a slightly discrete point where I opened the case. In paragraph 29, he makes it clear that more fundamentally, the right of access to justice, both under domestic law and under EU law, is not restricted to the ability to bring claims which are successful. Many people, even if their claims ultimately fail, nevertheless have arguable claims which they have a right to present for adjudication. And that's one thing that, as I say, my learned friend's approach rather overlooks, because if our right is to get to a decision that doesn't involve a judgment debt in our favour, then there can't be any justification for imposing or requiring a stay on the basis that one is only concerned with the prospect of us winning. So that the two point, that's the first point one takes from that paragraph, my lords. The second point, of course, is that Lord Reed makes the important point that it is for adjudication. The right of access to the court is not to walk through the door and then have the court refuse to see you, as it were, or even to have the door slammed in your face. The right is to get through the court door and have the adjudication of your arguable claim. And that is why it is wrong to say, I think as my learned friend did, that there is no authority for the proposition that the fundamental right of access goes beyond letting you through the door. It clearly does, and that's the highest authority.
Well, that's clear from Mrs Justice Laws's judgment, because although the context was something would affect your right to go to court, yes, the way in which his entire judgment is phrased is in terms of a fundamental right, as opposed to something which is effectively a hollow right.
Yes, exactly, my lord. And of course, Mr Justice Law's case involved opening the door. That was what fees, and that's why he talks about it. But the principles at play are much, much deeper. Yeah. And you can understand why, because it is a hollow right if it's anything less than actually getting the machinery of the state to resolve your dispute, your claim, to declare what your rights and obligations are. So that's that, my lord. Then, in terms of the constitutional rights of access and the what is said about that, can I just direct you, please, to paragraph 66, page 4247, where his lordship begins with, under the title, the constitutional right of access, with the statement that is inherent in the rule of law. Now, I'm not going to read all of that to your lordships, but it's important, and it's rather well set out there by Lord Reed for the Supreme Court. Can I then ask you to turn over to paragraph 74, which is on page 4249. Again, this is bread and butter perhaps, but it's worth bearing in mind. Lord Reid there invokes the Magna Carta and of course the Bill of Rights as the ultimate origin of this right. And that is indeed the level at which we are concerned. And the final sentence of 74 says, those words are not a prohibition on the charging of court fees, but they are a guarantee of access to courts which administer justice promptly and fairly. And obviously that goes to some extent to the idea that an indefinite stay might not curtail your right of access to the courts. It clearly does. He then cites Sir Edward Cook and Blackstone, and I commend those passages to your lordships, but I won't read them out. And he then, in paragraph 76, recites various of the cases recognising the constitutional nature of the right of unimpeded access to the courts, including the Times newspaper case, the Bremer Vulcan case, and so on. And if you just pick it up at the bottom of there, no, in fact, perhaps in the middle, my lords will see a reference, I hope, to 5 lines down, the case of In Re Bowler. And Lord Reid says, where the
Sorry,
in that,
I have, oh yes,
76,
yes,
5 lines
yes.
down, Lord, yes. In Re Bowler, where the question was whether a statutory prohibition on vexatious litigants instituting legal proceedings extended to criminal proceedings. The Court of Appeal held that it did not. Mr Justice Scrutton said at page 36 that although a statute might deprive a subject of the right of appeal to the courts, quotes, the language of any such statute should be jealously watched by the courts and should not be extended beyond its least onerous meaning unless clear words are used to justify such extension. And similarly in Chester and Bateson, where delegated legislation prohibited the bringing of legal proceedings without a minister's consent, the Divisional Court held that the regulation was invalid. Mr Justice Avery stated, and I quote, nothing less than express words in the statute taking away the right of the King's subjects of access to the courts of justice would authorise or justify it, close quotes. He then cites to similar effect the House of Lords in the Paul and Wheat Commission case. And picking it up in the final sentence, he quotes Viscount Simmons in Pick's Granite, where he said, it is a principle not by any means to be whittled down that the subject's recourse to Her Majesty's courts for the determination of his rights is not to be excluded except by clear words. Just another couple of discrete points, my lords. Paragraph 80.
I think we might note in 77 that the quotation from Lord Diplock also supports the suggestion that the right is in relation to determination of the disputes.
Indeed, my lord, that's right.
The
Not just
arbitrament of the tribunal,
correct.
is decision making, not just access.
Yes, ma'am. 79 recites more authority from the House of Lords that you have to have an express enactment taking away rights of access to the court. That's Lord Bridge of Harwich in the Raymond and Honey case. Paragraph 80 makes the point, as Lord Reid's own judgment, as it were, that if there is a power to intrude upon the right of access, it has to be interpreted as authorising only such a degree of intrusion as is reasonably necessary to fulfil the objective of the provision in question. Just picking that up separately again, if it is correct, and I don't accept it as you know, that judgment can't be entered for a money sum, this is the clearest authority that the court must give as much effect to the right of access to the court, including every possible step up to the entry of a money judgment as possible, unless the enabling statute has got express words to carve that even out, even further back, to pare it further back. And that's why, as I say, in some ways it's a slightly academic question on one level, whether a judgment can or cannot be entered, because on no analysis in my submission is there any authority for the idea that there could possibly be a stay of a claim at this point, even if judgment couldn't be entered for money in 2 or 3 years' time.
Well, isn't that a discretionary question?
Well,
And at the discretionary stage, the points you're making about access to justice come into the equation. They may well carry the day, they may not.
my lord, I would submit, if they are a discretionary question, it's a question that has got a black and white answer that your lordship should answer.
Well, you say, as on some submission you made based on paragraph 80, that at this stage, we have to consider whether, even if the statute authorises an intrusion on the right of access, the only possible interpretation is to grant stay now, as opposed to taking one or other of the other steps that you propose, such as a declaratory judgment in due course or a judgment on liability in due course. I mean, we're going to have to deal with what you described as Mr. Rabinowitz's problems. They're a different issue. The issue we're on at the moment, what you say is, well, whatever may or may not happen at trial, there's nothing here that requires the proceedings to be brought to an end by a stay for the indefinite future.
Yes, and I think the answer. So what I think that's right, my lord, if I may say. I'm not sure your lordship quite encapsulated what my submission was at the beginning, as opposed to my learned friend's, but if I could just recapitulate. My learned friend's case is that because judgment can't be entered for a money sum under the sanctions regime, there must now be an immediate stay. And he says, and that's supported by his argument that there can't be adverse costs orders and things like that.
That's his case on the application.
Yes.
That was his case on the appeal. And when he got to the stage where he was going to say the second half of that follows from the fact that entering a judgment would be a breach, we stopped him and said, isn't that all a matter of discretion?
Yes, and then he suggested, your lordship, that it was, and that he'd be content for it to be remitted.
Right.
And the bench indicated that that might find favour. What I'm submitting, in answer directly to your question, my lord, is there is no conceivable basis, properly arguable basis, for a stay at this point, on the basis of the case my learned friend puts forward, that could possibly mean a stay is appropriate when there are what he calls the workarounds, but I call the ways of accessing justice that are available to a citizen in this country that I've described. And therefore, whether your lordship describes it as discretion or not, my submission is that your lordship should first of all decide the question of judgment entry in my favour. Secondly, decide in any event that what are called the workarounds, but are in fact rights of the ways of accessing justice and a determination of the court, are possible under sanction. They're not affected by sanctions regimes. And I do invite the court at that point to say, well, if that's all right, if I'm right on that, there is no basis on which to attack the judge's decision not to stay. Because nothing, in my submission, there is no factor that one could bring into the equation on a stay application if your lordship's found for me on what are called the workarounds, but I'm keen not to diminish in that way, that could possibly justify a stay.
So just to be clear, even supposing we accepted Mr. Rabinowitz's submissions on all the licensing powers, or the fact that things couldn't be licensed, you would say that those could not reasonably justify a stay?
Yes, but now I'll come on to say what I say about the licensing powers. And I was trying to focus for this purpose on the judgment entry point and the alternatives to an ultimate money judgment. And I accept that my learned friend's case involves everything taken together. But my point is this, my lord. Your lordship, for example, raised stale evidence, witnesses dying between now and whenever a trial might come on if it's stayed pending sanctions and things like that, which I was going to make as points in due course. But in my submission, even if none of that could be said in my favour, as it were, there would still be no good reason for a stay now on any proper analysis of the legal provisions in the sanctions. They allow so much access to the court to determine our rights and obligations by declarations, judgment on liability with quantum to follow, conditional orders, stays of execution, whatever it may be, that no countervailing factor could possibly be relevant in a stay application that would suggest that there could be a stay. And of course, your lordship hasn't heard of any submission from my learned friend. So as I understand it, there's no part of his case that there's any other reason for a stay than that he is right on the law. And my submission is that he's wrong on the law, but even
if you're right about workarounds.
Yes, he's wrong on the law, but even if I'm wrong on the judgment point and he's right on that bit, there's still no good reason and nothing in the balance.
If you're right about workarounds.
Of course. But that's right. And you've got my submission, which is sensible, the point of this opening, that if there is a way of determining a litigant's, a plaintiff's rights and liabilities that is short of entering a judgment, if that is not allowed, then the court has a constitutional duty to do it. And if you're not going to, if that is not a workaround, the task of this court is to find in Samler unambiguous and specific wording that mandates a stay nonetheless. And of course there is none. And you can't even get close to a necessary implication, even if that's really possible, as Mrs Justice Law has said, because my learned friend doesn't point to any. He simply says that the effect of a group of different aspects of the legislation means that a stay must be ordered. But there are no words to that effect at all on any analysis. And I do ask the court to ask itself, if you like, what is the right of access to the court for a determination of civil rights and liabilities if it is not at least a declaration of who is right and who is wrong? Now, there is authority in the case of A against B, Authorities Bundle, tab 22, 2275, paragraph 12, where Mr Justice Collins says that legislation purporting to remove rights of access to the court is prima facie contrary to the rule of law. Don't need to take you to that, but that's obviously correct. And the question is therefore, and he quotes Lord Justice Denning's decision in Re Gilmore, are there, quotes, the most clear and explicit words in the statute purporting to remove the rights to take away those rights? And that is what we are looking for. Now, my lord, my learned friend has rightly not gone too far down the road of suggesting that there is something in the suggestion that sanctioned people are so reprehensible that they shouldn't have any rights of access to the court. That would obviously be a bad submission. One of the benefits of a country that does have the rule of law is that even pariahs can take advantage of it. And I use the word pariah because that was how VTB Bank was described in the BVI case my learned friend adverted to, I think took you to, where it was said by the solicitors acting for their client that reprehensible entities such as state-owned Russian banks should forfeit the right to litigate. And the judge in that case rightly said that was no part of the common law approach to anybody who has the right of access to the court. And there's even though my learned friend likes to, if you like, lump together sanctioned entities, designated persons, terrorists, Al-Qaeda, none of that is obviously relevant at all to the question of whether any of those individuals or groups or banks or corporations have the right that is described as constitutional in this country to come and get their rights determined. My learned friend referred several times to the article by Mr. Philip Sales, as he then was in the LQR. That's Authorities Bundle 108, tab 108. It might just be worth noting something in that article, page 3, page 4985 of the bundle, I think, of where it is, because your lordships have gone through and marked it up in other places. But I'm looking just past halfway down on 4985. It's hard to describe, but perhaps if your lordships can see between footnotes 27 and 28, probably easiest to isolate the sentence I would like to refer to at this point. After footnote 27, there's a sentence that finishes. And then it says, in the United Kingdom, as a state subject to the rule of law, the courts have always emphasised a particularly strong presumption against depriving individuals of the right of access to the courts, and have accordingly interpreted ouster clauses very narrowly indeed. Now, just pausing there, my lords, where is the ouster clause that my learned friends rely on to deprive my clients of the right of access to the court? There's only one ouster clause in Samler that can properly be called an ouster clause, or at least an explicit inroad into the normal right of access to the court, and that is in section 38, which my learned friend correctly says is a provision that, if you like, replaces the normal access to judicial review with a rather more streamlined version of it, in which damages are rarely recoverable. But that is a judicial review provision, or a streamlined provision, that only relates to the question of designation. Or, I suppose more accurately, as it turns out if you look at the scheme, section 38, a minister's decision not to revoke a designation on a challenge, because that's what it's limited to. So according to the principle of legality, and indeed in order to give effect to the fundamental right of access to the court, one has to interpret that ouster clause as narrowly as possible to give effect to what its object was. And there's no question what his object was. His object was to remove some of the rights a person in this country has to judicial review if they are designated under the statute, or a minister decides not to revoke the designation.
It's got absolutely nothing to do with whether a designated person has a right of access to pursue a civil claim.
No, my lord. So one is in this, there are 2 points. One is that the very right to removing judicial review has to be construed as narrowly as possible to achieve that objective, but it says absolutely nothing about the fundamental right of access to the courts for the determination of civil rights and liabilities at all. And so one has, in fact, in this statute, the clearest possible indication that Parliament did not intend, in any respect other than that in the narrowly to be interpreted article, section 38, to restrict the fundamental right of access to the court. In other words, to achieve the objective my learned friend wants, he'd have to have something in Samler that looked a bit like section 38, but unambiguously and clearly took away the right to have a civil claim determined under the law. And there obviously isn't anything like that. There isn't anything touching on the civil law rights and obligations of anybody in Samler, or the court's ability to determine those rights and to handle them and do its normal core function, which includes entering judgment. Except, as I've mentioned, section 44, which I may just have time to show you now. So just standing back there, my lords, the first point is clearly that there's nothing in Samler, which is where it would have to be found, that unambiguously and expressly takes away the right of access to the court in the relevant sense. What there is a very narrow and ouster clause for judicial review of designations, and even that has to be construed as narrowly as possible. What one has instead is a regime that first of all says the government or the executive can impose or can propose financial sanctions, they're called financial sanctions, amongst other things, other types of sanction, and they will be effective once made by regulation, subject to annulment by both Houses of Parliament if they don't approve them within 28 days. I think it's called the made approved process. So, my lord, just picking that point up, the regulations when they come into force are not anything to do with the intention of Parliament. What you're looking for in the regulations when they come into force is what the intention of the drafters was. Because the only mind that went into the drafting of the regulations is the executives, the minister who makes them, and the only opportunity Parliament has is to either approve them in whole or to disapprove them. And that's 28 days later, potentially, and therefore they come into force immediately, they must have meaning before Parliament addresses its mind to it. I don't think anything really turns on that, except perhaps that it's relevant to know, as we'll see tomorrow, that the executive who drafted the regulations has published material that tells you what the executive believes they do, they achieve, and what what they say, what they mean. And there's a limit to the relevance of that material or the potency of it, but there is in fact a provision under the Act that requires the executive to issue guidance with statutory force in relation to the meaning of SAMLA and the sanctions regime. And we'll look at some of that tomorrow. But that may be where the only place it's relevant. So one has a law that says you can impose financial sanctions on people for the furtherance of foreign policy objectives, essentially, or UN regulations or whatever. You then have a particular procedure carved out for replacing normal judicial review for people who are designated. That's the Section 38 regime. But there's nothing else to say, well, there are also these restrictions on anybody's right to come to court, to get the court to do its normal core functions. What you see, in fact, is Section 44 of page 806 of tab 11 being the only actual
Page.
806, my lord. I think. Authorities 11806. Being the only relevant statutory provision that actually relates to civil liability or obligation. This is called protection for acts done for purposes of compliance. And as we'll see tomorrow, it's in a way the manner in which the English legislature has decided to give effect to the no claims type clauses of the sort one saw in Article 38 of the Iranian regulations, that is the subject of the Modsaf case, or Article 11 of the EU regulations in the Russia in the case of Russia. That doesn't appear in that form in the English legislation. This is the alternative. It says this section applies to an act done in the reasonable belief that the act is in compliance with regulations under Section 1 or directions given by virtue of Section 6 or 7. We don't need to worry about that. Regulations under Section 1 are financial sanctions of the kind we've seen in the 2019 regulations. And the operative provision is this: a person is not liable to any civil proceedings to which that person would, in the absence of this section, have been liable in respect of the act, or omission as it defines it. So it's a circuitous definition intended to achieve the object that if you do something believing you're complying with the sanctions, you can't be held liable in a civil court.
And indeed, I see it adds in act includes omission, which you need for the Modsaf type case.
Quite my lord. And so if, for example, if you're sued, well, let's take the archetypal case, of course, would be a designated person who sues another person saying, I've got a contract under which you owe me $1 million, pay me. The omission in the question would be the failure to pay, because that would breach Regulation 12, potentially, if it happens in the jurisdiction, because it would make available to the designated person funds. And leave aside all the complications about whether that's a pre-designation obligation as an exception. Let's assume it's all post-designation. This effectively gives a civil defense, a defense in civil law to the liability of the designated person in those circumstances. But in a sense, they're clearly the primary intended target of this provision, so they can't sue people who comply with sanctions. But that must mean that designated people can bring claims against third parties in the civil courts in which they can attempt to establish that there is no defence under Section 44.
Does it go as far as you would like it to? It means they can bring claims sometime. They might no longer be designated.
It certainly would apply beyond designation, perhaps, if it's got a similar effect to Clause 11, Article 11, Article 38. But, my lord, there's nothing to suggest this doesn't apply during designation. Nothing at all. And I've made the point at the beginning, there's nothing in fact to suggest it only applies to the designated person making the claim. It also provides a defence to a designated person from fulfilling his obligation. So, for example, in my case, if the roles were reversed and the non-designated person sues the designated person during designation, saying you owe me $1 million, and the designated person says, I can't pay you because my money's frozen under SAMLA, this provides a defence to the designated person. But all of that, and of course that shows you that you can have claimant or counterclaimant. The designated person can be claimant or counterclaimant or defendant. There is no suggestion in section 44 that there is any restriction whatsoever, other than where the defence applies as a matter of substance, to the civil court determining the rights and obligations of designated persons before or after designation, or in respect of obligations arising before or after designation. And if one were going to try to read into Samler the kind of intrusion into the fundamental right of access to the court for designated persons that my learned friend seeks to read, section 44 would have to contain it unambiguously and clearly. And it doesn't. In fact, it's quite the contrary. And it makes it clear that there will be claims, no doubt, where a designated person sues a non-designated person, and the non-designated person says, in fact, I haven't paid you because of sanctions. And the court said, no, that's not right. You could have paid despite sanctions, and therefore you are in breach of contract, and I'm entering judgment in favour of the designated person. And my lords, just to finish off, tantalisingly perhaps, there are 2 cases in the English court in which that very thing has happened, under the EU's Iranian regulations. And we put those into the supplemental bundle. They're the DVB Bank case, which is a Chancery Division decision, supplementary bundle, tab 9, and the Melly Bank case, tab 10, both of which are cases where the English court has entered summary judgment in favour of a designated person for a money sum because it has been satisfied that the defendant's excuse for non-payment was not sanctions related.
Sorry, which?
Supplementary tab 9, my lord, and supplementary tab 10. I hope they've found their way in there because there's been a little bit of addition to that set. What your lordships won't see in either of those 2 argued decisions where both sides were represented and the court grappled with sanctions in each case is any suggestion by anybody, still less the court, that it was somehow unable to enter judgment for the designated person once it had decided that there was a claim that did not have a defence due to the sanctions-related provision, which would have been Article 38, presumably, in those cases under the Iranian sanctions. And there's no argument to the contrary, of course. It doesn't arise. But my only point at this point, my lords, is that it's a rather unpromising start if your case requires you to prove that there is something unambiguous and clear and express on the face of a statute preventing the entry of judgment. That at least 2 constitutions of the court in this country has nonetheless gone on to enter judgment in favour of designated persons for money.
Do you just give us the passages in the judgment that you rely on?
They should be sidelined, my lord, and I'll just, because the key points here are the passages that show that the claimants are sanctioned, and we've sidelined those where they occur at the top.
Yeah.
And then the conclusion at the end, which is that the attempt to argue that there's no obligation to pay because of sanctions fails, and summary judgment is entered for each of the claimants, which is effectively the conclusion. The middle parts of it are all sorts of arguments about frustration and public policy and that sort of thing.
Yeah.
But there's no point going through that now because I would be, if you like, looking for a negative point to make.
No,
There's nothing there that suggests that anybody had the slightest qualm. And my lords, my simple submission is that that's consistent with section 44 or its predecessors in the Iranian regime. And it can hardly be said to be clear, unambiguous and obvious from the face of the sanctions if this sort of thing has happened.
Yeah. Convenient moment, Mr.
It is indeed.
And how are we doing on time?
Well, my other friend and I had agreed that he would have overall an hour more than I had out of the 4 days. Because he's opening the appeal and had to show your lordship some of the materials. So By my reckoning, I have to sit down by 2:45 on Thursday to give him an hour and a half, which is what he's left for himself. I'm quite confident we'll be finished before then on our side, but can we see how tomorrow goes, my lord?
No, I only raise it just in case you wanted us to sit early on either day.
I don't think so at the moment. And if we make good progress tomorrow, it won't be necessary on Thursday. But
Okay, well, all right. 10:30 tomorrow.
All right.